extremely grateful to Justice Sujata Manohar for inviting me to speak today on a subject which is close to my heart, the Indian Constitution. Although it does give me some leeway to conclude, or at least put forth an adverse view, that constitutions do not, or perhaps may not matter. Doing that would firstly have us confronting the perils of the collapse of our constitutional democracy, and secondly, for me, the peril of being out of my own job. So let me begin by stating which side of the line I stand. Our constitution does matter. The Indian constitutional project did not commence on 9 December 1946 when the Constituent Assembly sat in New Delhi for its first session. It first echoed in the battlefields of Bengal in the 1857 rebellion. Lokmanya Bagangadhar Tilak, whose famous trial took place in this courtroom, was among the first to call for Purna Swaraj. For many decades prior to the coming into the force of our constitution, the Indian self-rule movement was a mass movement and encompassed many sections of society. The call was simple: a governing document of the people, by the people, and for the people. The constitutional culture in India predated the coming into force of our constitution. Before the advent of our constitution, a well-known demand had emerged to establish, through the participation of the people, basic rules and principles of behavior which would constitute universally binding legal norms. The Constitution was to mark a transfer of the power to steward the destinies of its citizens. So the first important facet of the Constitution which I want to emphasize, that this is a document which marks the transfer of colonial power. The Constitution was to put in place an organic structure that would sustain the country's independence and freedom, equipped with the tools for social revolution, as noted historian Granville Austin called it. So a parallel movement was taking place during the times of the freedom movement, which we shouldn't lose sight of. The parallel movement, together with the movement for freedom, was a movement for social emancipation, the movement which was begun by people like Dr. B.R. Ambedkar, but even before Baba Saheb Ambedkar, by people like Phule. This potential of a constitutional document in steering the course of the society it governs lends it paramountcy in comparison to statute law. A quote by Carl Schmitt comes to mind. The essence of the Constitution, he says, is not contained in a statute or a norm, but in a prior and fundamental political decision by the bearer of the Constitution-making power. In a democracy, this is a decision by the people. The Constitution owed its validity and authority to its own people, rather than to the fact of its enactment by a foreign legal process. In way fashion, we the people, through the members of the Constituent Assembly, came to be the source of authority of the Constitution, rather than the Indian Independence Act enacted by the British Crown and Parliament. The advent of the Indian Constitution thus marked the coming together of a population, the culmination of a desire for self-governance. It represented a bottom-up approach where the people granted to themselves their structures of governance. In Nani Palkhiwala's words, the Constitution represents the charter of power granted by liberty and not the charter of liberty granted by power. Liberty is not a gift of the state to the people. It is the people enjoying liberty as citizens of a free republic who have granted power to the legislature and to the executive. The Constitution was required to take into account multiple conflicts. Let us understand that this is a constitution which is founded in a history of multiple conflicts. Freedom of expression and national integrity, personal liberty and political stability, special treatment for some segments of society and equality for all, property rights and social revolutionary needs. The people who work the Constitution may go terribly wrong, and sometimes they do, as when we jail a cartoonist for sedition, or when jail instead of bail is given to a blogger who is critical of our religious architecture. When a mob lynches a person for the food that she or he eats, it is the Constitution which is lynched. When we deny to human beings the power of love for reasons of religion or caste, it is a Constitution which is made to weep. That is exactly what happened yesterday when a groom belonging to the Dalit community was asked to climb down from a horse in a wedding procession. Let us make no two bones about it. That is the Constitution which weeps when we read of such incidents. Courts have played an important role in recognizing the autonomy of individuals within the Constitution to determine their orientation as well as their gender identity. It was my belief, while writing the Section 377 judgment, that we the people of India, in our preamble, must be an ever-inclusive and expansive we. The we in the we, the people of India, is not prefixed by only, stating only we or any other such prefix connoting religious, caste, class, sex, or political ideology or ideological affiliation. It is a simple and obvious interpretation. But as George Orwell said, the work of intelligent people is to restate the obvious, because the devil is very often in the detail. As people in the field of law, we would agree that the limits of our words are the limits of our world.
Friends, don't forget to subscribe to our channel and press the bell button for latest updates.